Good afternoon, everyone, and thank you for attending today's webinar, GP Surgery Lease Renewals, How to Avoid the Pitfalls. My name is Bryn Morgan. I'm a partner at Hempsons. Joining me today is my colleague Miles Evans, who is an associate. We are both in the Hempsons primary care premises team. Now, for many business tenants, lease renewals are tricky enough in terms of negotiating a deal with the landlord and navigating the renewal process under the Landlord and Tenant Act 1954. GPs, of course, have the added complication of the system of rent reimbursement and having to deal not only with their landlords and the 1954 Act, but also the ICB and the district valuer and value for money reports and such things. And the NHS lease approval process is governed by another piece of legislation, which in its latest form is hot off the press, the Premises Cost Directions 2024. So today, Miles and I will share some of our experiences of dealing with lease renewals for GPs, and we will be covering some practical tips on getting your practice into the best shape ready for a lease renewal. Then we'll move on to some thoughts on how premises improvements can or may be factored into the process. We'll then look at specifically at the process for renewal under the Landlord and Tenant Act 1954, and finally we'll have some thoughts on how this sits alongside the ICB lease approval process. I hope you find this useful, and as mentioned, we're going to have quite a good amount of time at the end for any questions and discussion. So please do put your questions in the chat function, and if you want to ask questions in person, you're welcome to. Just please save those up for the end of the session. So without further ado, I'm going to hand over to Miles, who will kick us off with some thoughts on preparing for a GP lease renewal.
Brilliant. Thank you, Bryn. Welcome, everyone. So as Bryn mentions, I'll be kicking us off with some practical tips on preparing for the expiry of your surgery lease. So the first one I've got there on the slide is to start early. We suggest or recommend beginning preparations at least 18 to 24 months before the lease expiry. Now, that may seem like a long time to some of you, but as will, I'm sure, become apparent throughout this presentation, there's lots to think about and potentially lots to do, lots of steps to take. So certainly start as early as possible. The next point is really to check in with your ICB. Check that your premises are part of their future plans, and that you have the ICB support to remain at the premises, and if so, for how long. You need to understand what the ICB's future plans are for the practice. After all, the ICB is funding the premises going forward, so it's good to check with them whether, for example, whether they have alternative plans for the practice in terms of potentially moving to new premises. It's also just a good practice to have the ICB on board at an early stage with your plans, so that you don't run into unexpected problems later down the line in terms of what the ICB is and isn't willing to fund. The next point on the slide there is good housekeeping. So that's just a recommendation to compile all of your relevant documents. So obviously your lease, there may also be deeds of variation if the terms are being varied at some point. There may also be schedules of condition, surveys. You also want to be checking that the lease is held in the names of current partners of the practice. If the lease is registered, you can do that by getting a copy of the title from the land registry and just confirming that those that hold the lease are in fact partners of the practice. If it turns out that that's not the case, and perhaps there are retired partners that remain on the lease, as it were, then that's something that you should be sorting out and dealing with sooner rather than later, so that it doesn't cause problems further down the line. So once you have those, you've compiled those documents, you should familiarize yourself with the terms of your current lease. So have a think about what are the main terms, look at the extent of the premises, i.e. your demise. Is it sufficiently large enough to accommodate your needs? Is it perhaps too large, and there's a possibility to shrink your space? Think about the term length that would be appropriate for your renewal lease. So, you know, if you have potentially future plans to move on, in that case, you might be looking at a shorter lease, or if you perhaps want to stay long term for the future, you'd perhaps be looking at a longer lease. And then the other point to think about is break options. So do you need an element of flexibility over the coming years to make sure that at various stages you would be able to extract yourself from the renewal lease going forward? Once you've had to think about those sort of main terms, I would also suggest putting together a wish list, if you like, and having that in mind when you're sort of moving on to the next stage, which is to engage with your professionals. You want to have a rough idea in terms of practically what you're thinking about for the future. So as I say, the next stage would be to then engage with professionals. So we would recommend instructing a primary care specialist surveyor to assist you in negotiating the commercial terms, often called heads of terms. They're simply the sort of principles of the deal, as it were. They are agreed subject to contract, so which briefly just means they're not legally binding. You won't be legally bound to anything until the lease itself is completed. Obviously, one of the benefits of having a professional primary care surveyor in your corner is that they understand the GP and healthcare market. They'll be able to negotiate commercial terms with your landlord on your behalf. They also have or should be familiar and have knowledge of the ICBs and district valuer requirements in terms of leases, and in particular how the changes to the lease terms feed into what is ultimately the market rent. Because the important point to keep in mind is ultimately the ICB, as advised by the district valuer, want to be looking for value for money. They want to ensure that that new lease reflects value for money, and a surveyor will help you to achieve that. There's also an expectation on the part of the ICB that they see that you know that negotiations have been carried out between landlord and tenant before you go to them for on the question of funding, and having the surveyor in your corner sort of makes it easier to easy to show that you've done that. I'd also recommend instructing healthcare specialist property lawyers. They can look at the heads of terms from a legal perspective and offer advice on some of the more technical points, and possibly they could also look for you at your title to the property to check whether there are any issues there that might come up later on in negotiations that should be dealt with at the outset. And finally, the final point there is just to open up communications with your landlord as soon as you can, preferably through your surveyor. You want to initiate those discussions to really gauge the landlord's intentions as soon as possible. You know, do they want to keep you as tenant long term? Be clear about your intentions to remain at the premises and secure a new lease. And at that point, you will also be putting forward the that wish list that we discussed earlier, and putting forward the potential changes that you might want to make to your existing lease, and reflect those in the new lease. So those are some hopefully helpful practical pointers. I'll now pass over to Bryn. He's considering the renewal as an opportunity to improve your premises.
Thank you, Miles. Yeah, as you mentioned, a lease renewal is often a great opportunity to look at the state and condition of the surgery and see if there are improvements that can be brought into the process. We've seen a number of schemes involving internal reconfigurations and refurbishments, and some with extensions to provide additional space. So whilst improvements can be funded by the practice itself, this is usually uneconomic, and of course tenants will not usually wish to invest heavily in improving premises owned by someone else. But there are other methods of funding improvements, and we've got a couple on the slide here, that these being the possibility of getting an NHS improvement grant, or perhaps the landlord may be willing to invest in the works. Sometimes schemes involve a bit of both, so there may be some grant funding and maybe a bit of money put in by the landlord as well. Under an improvement grant, it may be possible to fund significant refurbishments or extensions. These grants are typically supported by a grant agreement between the practice and NHS England or the ICB, and will usually there will need to be some assurances that there is a suitable length of lease in place to support the investment. Incidentally, the thresholds for those time periods have recently changed under the new premises cost directions. So, for instance, a grant of, say, £250,000 is likely to require a lease of at least 9 years. But just by way of example, there are other thresholds depending on the amount of money that's being granted. The landlord may also be prepared to fund works, as we said. So why would the landlord want to do that? People, I'm sometimes asked. Well, for some specialist primary care investors, such as PHP and Assura, they have an interest in maintaining modern, fit-for-purpose facilities, but they also will potentially benefit from securing a higher rent to reflect improvements, and also a new lease for a guaranteed period of time. It's worth remembering that as GPs, you are considered a blue chip covenant for your rent, as it is effectively state backed, which makes GP premises investment a fairly safe investment for the market. So that the value of just having an extended lease is something in itself to your landlord, which is something to remember when you're negotiating. In terms of obtaining ICB sign-off to improvement projects, whether funded by a grant or increased rental funding, availability of funds is likely to be tight, as we know, and competitive. So it's crucial to put together a well-structured business case showing not only the benefits to the practice, but also to the ideally to the wider system, particularly highlighting examples of where the changes and improvements will support integrated care. This all requires time and effort, which is another reason, as Miles has indicated, as to why it's better to get these plans in place sooner rather than later, in advance of a lease expiry. But you don't necessarily have to wait for a lease expiry for improvements. Indeed, we've seen a number of cases where there have been pressing needs for expansion of existing surgery premises midway through a lease, possibly due to a local development which has generated population growth with need for new facilities. So it is possible with to what we call a lease re-gear, where you agree to a new lease midway through an existing lease term. So do bear in mind, it's not just the expiry point that you can be looking at these sorts of options. I think it's worth mentioning that GPs do need to be aware of their responsibilities under lease repairing obligations, and also the minimum standards that are imposed under the NHS contract and set out in the premises cost directions. So when we're looking at improvement grants, we are looking at grants for things that will, are not simply just trying to put in repair things that have been left to fall into disrepair. And indeed, NHS England have made it very clear under the in respect to the new premises cost directions that compliance with these standards won't be funded, and that practices shouldn't be allowing premises to deteriorate to the point where wholesale refurbishment is needed. Now, I just mentioned that not to say categorically you cannot get repairs dealt with as part of these processes. I think there are grey areas, and there are, if you can show things need to be replaced and improved that way, then obviously that does do away with certain dilapidations issues as well. But it's worth bearing that in mind when you're putting a case to the ICB. You should be avoiding trying to, making it out, framing it in the sense of putting into repair what has been allowed to fall into disrepair, and you're thinking very much about what are improvements over and above those issues. It's also worth bearing in mind that if you have a full repairing and insuring lease, which is where you're responsible for the structure and exterior of the property, or for the costs of those parts, you should be receiving what's called an FRI supplement, which is normally 5 to 7.5% of the rent that's paid to the landlord. So that is funding towards repairing costs. So that we do always recommend that practices set that aside, ideally in a sinking fund for the costs of repairs, and obviously supplement that with other what money is required to fund internal repairs as well. So I'll now hand back over to Miles, who's going to talk to you about the 1954 Act.
Brilliant. Thanks, Bryn. So I'm going to give an overview of the Landlord and Tenant Act 1954, at least insofar as it relates to lease renewals. I'm going to try and keep it simple, as there's a risk with this topic of getting bogged down in some detail that's probably unnecessary for our purposes here. So what does the 1954 Act do? Well, in short, it gives security of tenure to business tenants. What is a business tenant? A tenant who is in occupation of premises for the purpose of carrying on a business. So what is it? What is security of tenure? How does it protect tenants? Well, there are two ways. The first is that a lease that benefits from security of tenure will continue when the contractual term of that lease comes to an end. So the tenant has the right to remain in occupation, paying the rent, complying with the terms of the lease under what's referred to as a continuation tenancy. So it rolls over effectively as if nothing has changed. So, for example, if you are granted a 10-year lease that benefits from security of tenure, when that 10-year term comes to an end, then the lease effectively continues. When the 10-year contractual term comes to an end, the lease effectively continues beyond that date until one of the parties takes action, which I'll come on to. If you contrast that with a lease that's again granted for 10 years outside of the Act, i.e. does not benefit from security of tenure, when that initial 10-year contractual term comes to an end, the tenant then has no right to remain in the premises. So you can imagine the difference in negotiating position between a tenant whose lease benefits from security of tenure and a tenant that doesn't. The second way in which security of tenure is a benefit is that it allows for a statutory right to renew in favour of the tenant on substantially equivalent terms as the renewal lease. So on the question of the terms of the renewal lease, I'm going to come back to that a bit later. But briefly, that let me just move the slide here. Sorry, that right to renewal is subject to certain limited grounds on which a landlord may oppose that renewal. I'm not proposing to run through all of the grounds that are on the slide now, but just to pick a couple, grounds F and G there. So I think it would be fair to say they're perhaps the most common grounds on which a landlord might oppose a renewal. So ground F is demolition or reconstruction. Ground G is where the landlord intends to occupy the premises themselves. So in those scenarios, the landlord would be able to effectively not grant the renewal lease. And the reason I've just flagged those particular grounds is they are what we call no fault grounds. So the tenant itself is not at fault. And in those scenarios, a tenant is entitled to some statutory compensation, which is limited by a calculation relating to the rateable value of the premises. So just going back to the example I gave with the 10-year lease that's within the Act that's continuing, that continuation could continue for months or years. The sort of status quo. Thanks. Me off. Thank you. But the status quo of that continuation is going to have to change at one stage. So eventually, either the landlord or the tenant is going to require some more certainty. One of the parties will either want to end the continuation tenancy or enter into a new lease. And from a landlord's perspective, they are unlikely to sort of accept long-term not knowing whether the tenant plans to stay or not, as most landlords require some certainty of income, particularly from a valuation perspective. The value of the landlord's asset can have a good deal to do with the guaranteed income they can expect to generate from the building over a long term. And from a tenant's perspective, it's also difficult to plan long term for the business or the practice if you have, if you don't know whether or not the landlord planned to grant a new lease to you or not, or whether the landlord has some other plans for the building. So the question is, how does that sort of status quo, the continuation tenancy, change? Well, this is where the notices under the 1954 Act come in. There are two types that are relevant. You have a Section 25 notice and a Section 26 notice. The Section 25 notice is a notice served by the landlord on the tenant stating that they want the tenant to take the new lease. The terms of the new lease will be attached to that notice. On the other hand, a Section 26 notice is a notice served by the tenant on the landlord, stating that they want the landlord to grant a new lease to them, and again they would attach the proposed terms for the renewal lease to that 26 notice. There is another form of Section 25 notice, which is the one served by the landlord, which links back to the grounds of opposition I mentioned earlier. So a landlord may serve what's called a hostile Section 25 notice, in which they set out the ground on which they are seeking to recover possession of the premises. So the important point really is that once one of the notices is served, there are then complex procedural steps and there are hard deadlines to observe, none of which I'm proposing to go into now. It's too much detail for our purposes, but there are also tactical considerations to think about as well. But I would just say that it's essential to seek legal advice if you receive a Section 25 notice, or if you plan on serving a Section 26 notice. Going to court in this process will be very expensive, so that should really be viewed as a last resort. So again, I would just reiterate that getting appropriate advice early and having a strategy will serve you well. So just if you think about the notices as the trigger to get the ball rolling, as it were, on the formal negotiations with the landlord. Once a notice is served, that is the trigger that sort of forces, if you like, the parties to engage around the terms of the new lease. So that brings me back to the point I raised earlier about the what are the terms of the renewal lease. So it's important to understand, I think, that ultimately the terms of the renewal lease could be decided by the court. No one wants to end up there, but that possibility needs to be understood if the landlord and tenant can't reach an agreement. So that sort of creates the sort of backdrop or the context of for the negotiations between the landlord and tenant. Both sides need to consider, or at least have in the back of their mind during negotiations, what the court might end up granting if it were to go that far. Which, as I say, both sides have a good deal of interest to avoid that process. So it's Section 35 of the Act that's relevant. So Section 35 states that the terms of the new tenancy will be either as agreed between the landlord and tenant. So as I say, the landlord and tenant are free to agree any terms that they like, or if an agreement can't be reached, or as determined by the court, having regard to the current tenancy and all relevant circumstances. So it's the and all relevant circumstances phrase there that gives the court wide discretion, and it's that element of the wording that sort of forms the basis for the negotiations between landlord and tenant. Both sides will argue why their particular clause they're seeking is sort of fair and reasonable in the circumstances. But more fundamentally, the starting point, to be clear, is the terms of the current tenancy. So if you are seeking to include new terms that were not included in the existing lease, you may have somewhat of an uphill battle on your hands. Not to say it's not possible. It's just a case of that's part of the negotiation, and is why, again, it's advisable to have a specialist healthcare surveyors and healthcare solicitors on your team, as it were. I'll just mention briefly before closing that there is case law. It's called OMEI is the relevant case on this point about the terms of the lease, and the principle is that it's for the party that's seeking to change the terms, to move away from the terms of the existing lease. It's for that party to justify that change is fair and reasonable. Just a caveat to that principle does not apply to the rent or the length of the term, which will depend on what is reasonable, taking into account all of the circumstances. So I hope that you stayed with me for that. I hope that that's given you a bit of a flavour of the Act and how it works, things to consider. But now I'll pass over to Bryn, who will take us through the things to consider regarding the ICB's renewal approval of renewal leases.
Thank you, Miles, for that whistle-stop tour of the 1954 Act. Amazed you managed to keep that down to below 10 minutes. That's a
challenge.
Good stuff. Well, I'm now going to try an impossible task, and which is to try and weave together what Miles has just shared on the 54 Acts with some thoughts on the NHS approval process. Now, as mentioned earlier, the lease approvals for GPs are regulated by the Premises Cost Directions 2024. And unfortunately, these directions do not deal specifically with lease renewals as a separate, distinct category to approval of a brand new lease. They're all lumped together under the same direction. Indeed, the 1954 Act is not mentioned at all in the Premises Cost Directions. So this means that what we have is effectively a twin track process under two pieces of legislation produced some 70 years apart from each other, which unfortunately are not designed to work in tandem. This has caused headaches for a number of practices over the years, and unfortunately additional costs as they find themselves stuck between these two systems. So in our experience, problems can arise where ICBs are not engaged early enough in the process, and also through no fault of the GPs due to patchy resourcing at the valuation office, where the district valuers are advising ICBs on proposed lease terms as part of the approval process. So this resourcing issue that I mentioned is rather twofold. It's firstly there is a general lack of valuers to produce these reports for the ICB, and that has generated a backlog. Not only do they deal with lease renewals, they're also dealing with mid-term lease rent reviews, and of course for owned premises as well, notional rent. So there's a lot of valuation advice that's required by ICBs, and lease renewals are just another category of those areas that need this advice. So there is so in terms of the district valuers, they are, I think, under resourced and overworked, I think some would say. But I think the other issue is that we often find is that district valuers and the ICBs sometimes lack an understanding of the complexities of GP lease renewals, and particularly the strict statutory time periods that Miles has mentioned under the 1954 Act. We sometimes see value for money reports that advise that the ICB wants or should seek certain changes to the terms of the lease, without, I think, understanding that the ability to make those changes is very much limited by the OMA principles that Miles mentioned earlier. I think problems can also be encountered where either the landlord or the practice are not represented by specialist advisors who understand the premises cost directions. If, for instance, you've got a landlord who has a solicitor or a valuer who is unfamiliar with the directions, they won't appreciate the need for NHS approval, and they certainly won't understand the process that's involved in navigating through the approvals. And in some cases, landlords can get a bit fed up with things and push things down the lease renewal process under the 54 Act, which if that happens too soon, there's a risk of those court proceedings that Miles mentioned coming too fast towards you, whilst the NHS approval is still lagging behind. So it's also, I think, worth stressing that these two systems don't have a single this kind of resolution process, for want of a better term. So if you can't agree with the landlord what the terms of the new lease are, you have to go, say, potentially to the county court to resolve that dispute under the 1954 Act. But if, on the other hand, your issues are with the ICB in approving the terms for rent reimbursement, there's a separate appeals process under the NHS resolution arrangements. So again, they're entirely different tracks in terms of dispute resolution. So the ideal is you don't want to be getting into a situation where you have a dispute to resolve. Just as by way of example, a couple of years ago, I dealt with a GP lease renewal that was linked to a planned landlord-funded refurbishment. Now, negotiations had proceeded very well between the landlord and the GPs, and indeed, legal documentation had all been settled, with one major exception, and that was on the rent figure. Resourcing issues meant that the district valuer's report was delayed, and in the meantime, the landlord had protected its position by serving a Section 25 notice, as Miles explained, which starts the renewal process under the 1954 Act. Anyways, the clock ticked down towards the deadline for the court application under the 1954 Act. The DV did finally issue its reports, but unfortunately, one which recommended a rent that was far below the level that would make the scheme, i.e. the refurbishment works, viable. Not only that, the CCG at the time, to the surprise of everyone, said that there wasn't an appeals process available to that value for money decision. And the GPs found that they had no option but to move forward with the court process under the 1954 Act, whilst at the same time instructing us to put forward arguments to NHS resolution that there was indeed there should be an appeal of that value for money report. Well, to cut a long story short, we were ultimately successful. We did manage to convince NHS resolution, well, actually, whether they needed convincing or not, but they did agree that there was an appeals process on a lease renewal in terms of the terms of that new lease, and the parties came back to the table and were able to agree a rent that enabled the scheme to proceed. But I think, I mean, unfortunately, in all of this, it was the GPs that were left incurring the significant costs of having to go down the court process under the 1954 Act, but also the NHS resolution appeals process of the value for money decision. So I don't think really in that case there was really much the GPs could have done to help themselves. But I think and I think really it's worth stressing that this, I think, is hopefully a one-off and somewhat extreme case, but it does, I think, throw into focus the kind of the issues with this kind of twin track process that we have. I say one potential bright spot on the horizon is that the new premises cost directions do allow ICBs to seek valuation advice from not only the district valuers but also potentially now commercial valuers. So what remains to be seen whether increasing the pool of potential advisors helps speed things up, but I think that has to be the hope. But I think all of this just again throws into focus the need to try and start the process early, speak to your ICBs, speak to your landlord, and try and come up with some plans well in advance of the lease expiry, and certainly before you start serving notices under the 1954 Act. I think the worst thing practices can do in these situations is to effectively sleepwalk into a lease renewal process. And as we've mentioned a few times now, just do seek professional advice from specialists who understand primary care, both valuers and solicitors. And I'd say also, if you can, encourage your landlords to do likewise, because as I say, it does simplify things if everyone understands the landscape. So that concludes our talk on lease renewals. I know there are hopefully a lot of questions that have come up, so we'll turn to these now. Miles, are there any? Start at the top.
I think, Jess, were you summarising?
Yep. So just made note of them, so we'll start at the beginning. First question through is how do you check with your ICB? So Miles, I think this was to do with your top tips slide at the beginning.
Sorry, how do you check with your ICB?
Yes.
Well, yeah, I mean, hopefully the practice will have a contact within the ICB that they can communicate with about the lease renewal.
I think it's worth saying ICBs are required to have estate strategies, so it's worth finding out who at the ICB is responsible for looking at the primary care estate across your patch, and having conversations with those individuals to try and find out where your premises fits into that. But yeah, it's about I don't think we know the specific person in each ICB, but it's hopefully with some inquiries you can find out. I say do ask about who the estates people. Basically, I think that's is a good place to start.
Okay, thank you both. Next question. We have a 7 GP partnership, but on the current lease, 4 partners are named as holding the lease. The old lease is coming to its end in a few years. Is it possible or common practice now to hold the lease until the partnership rather than individual?
Short answer is no. It's not possible to hold the lease under the partnership itself. The partnership or a partnership is not a legal entity in itself. So it is the case that it will be certain individuals within the partnership that hold the lease on trust for themselves and the other partners. Yeah, it's just not possible for the partnership itself to be named as the tenant, as it were.
Yeah. I think it's also worth mentioning that so if there's a maximum of there's a maximum of 4 that can appear on the legal title. So do check land registry entries to see who those 4 are. It may not be the 4 that were originally signed up to the lease, because it may have been assigned in the meantime. The other point I think we mentioned earlier about housekeeping and keeping the names on the lease up to date. It's worth stressing under the 54 Act there, it is the name, those individuals that hold the lease who need to be in occupation for business purposes in order to be able to qualify for a lease renewal. So what you don't want to happen is for the lease to be held by retired partners who obviously no longer practicing, because then that opens the door to the landlord saying, well, actually, sorry, you've lost your protection because the individuals that hold the lease aren't actually practicing anymore. There is a partnership exemption under the Act which can help out practices where you may have 1 or 2 retired partners named on the lease and a couple of continuing ones. But the risk is if you don't have any current partners named on the lease, you're potentially in a spot of bother under the 54 Act.
Thanks, Brent. I think our next question, you may have just answered it there, but I'll read it out. In terms of names on the lease, we have 2 old partners still named and 1 partner who is not named. The lease is due for renewal in 2026. Is it worth updating the lease now or waiting until 2026 and do the whole renewal in one go?
Well, assuming the lease does have protection under the 1954 Act, I think just for that, the reason I just explained, I think it would be very sensible to get that updated. The other thing is, which we often find is when you get to the point when you need people to sign documentation, last thing you want is for having to be contacting partners that moved on or may not be contactable anymore. So it does cause, we've seen a number of kind of lease renewals, and particularly projects involving refurbishments where you need to enter into an agreement for lease, and they can get held up if you've got leases that are still in names of retired partners. So advice would be, if you can, try and get that sorted out in advance.
The next question, how much does it cost to change the name of a GP partner on a lease? Example, if a GP is planning to leave within 12 months of the new lease being signed, is it best for that GP not to be on the lease, or is it easy enough to change the GP names when the GP partner leaves?
Yeah, sure. So it's really up to the practice which of the partners are named on the lease. So what is commonly, not always, but commonly the case, is that the partnership may consider putting the partners who are perhaps likely to be latest to retire, as it were. And the point with that is sort of getting at what you're saying, is that you're trying to get around the issue of having the lease granted to a particular partner or partners who then shortly thereafter retire, and then having to go through the sort of administrative process of assigning the lease. Yes, that can be avoided by the partners who actually go on to the lease not being those that are sort of arranging to retire in the near future.
Yeah. Good. I think in terms of costs, I mean, it's we're always very happy to provide estimates based on specific circumstances. It's difficult to give a figure for any lease renewal because assignment, partially because it depends on what the terms of your lease say. Some leases require landlord's consent to an assignment, and that unfortunately does mean that there are more costs because you have to pay your costs and the landlord's costs as well, and there's more documentation involved. What we try and do is, when we're negotiating leases for GPs, we try and include provisions that allow for leases to be assigned between partners without having to go back to the landlord each time for consent. So if you've got a lease like that, it's a lot cheaper. It really depends on what your lease says.
Yeah, thank you both. I think they just commented afterwards that they're in a 7-partner practice, and is it best to put all 7 names on the lease, or just 4? Previously, we've just had 4 GP names on the lease.
You can only have a maximum of 4, so I think that's the point. It's the land registry will only, it's a old legal rule that land can only be held in the maximum of 4 individuals, so that includes a lease.
I suppose it gets to the other point as well about having your partnership deed up to date too, because if you're only having a maximum of 4 partners on the lease, you want it to be documented that the lease liabilities are shared between the wider partnership.
Yeah. And also what happens when a partner retires, and particularly if it's a partner that's named on the lease, you want your partnership deed to specify that the other partners will then step in and sign the lease, so that you don't have a lease liability following you into retirement.
Thank you both. So next question, if we do not have a lease and have not had one for over 30 years, where do we stand legally with NHS property services? And they've just mentioned that there's no rent arrears, etc.
Okay. That is a tricky one, because I think with any undocumented arrangement, we don't. You have to carefully analyse the facts to try and determine what arrangement has arisen by implication, effectively. And unfortunately, with informal document arrangements, the only way of getting an absolute clear-cut view on what the terms of the lease or what the arrangements are is to ask a court to determine position. Interestingly, there were those test cases between the BMA and NHS Property Services last year, and in those situations, it was most of those arrangements where the GPs didn't have leases. The court decided that those GPs were actually occupying under tenancies at will, and tenancies at will are essentially they are, as the name suggests, they are tenancies that are just continuing at the will of the parties. So they could in theory, be terminated at any point without any notice or recourse. And certainly under those sorts of arrangements, there wouldn't be any protection under the 1954 Act. Now, I think a lot of that is quite academic with GP practices, particularly with NHS Property Services as the landlord. As I don't think NHS Property Services are in the business of going around evicting GPs, and certainly I think they would, the political side alone would be quite an incendiary tactic. So I think it's very difficult. I think the answer to the question is it's very difficult to say what the legal position is without going into looking at the facts of each particular case. But we've got that. I think it's either going to be a tenancy at will, in which case you do need to at some point get a lease in place to give yourself longer term security, or potentially at a push in some cases there may be a protected tenancy under the 1954 Act, but again, one that, as Miles mentioned, could be brought to an end under one of the statutory grounds. So I think if you are, as long as I know a lot of GP practices have issues with rent service charges, but if that isn't, if that's not the case for you, then it may be, now's the time to try and regularise a lease.
Thanks, Bryn. So next question. You mentioned statutory compensation for tenants when no fault grounds happen. Who pays this compensation?
Sure. So this goes back to what I was talking about during my session there. So it's the landlord that pays the compensation. As I mentioned, it's based on rateable value of the premises. As I recall, if the practice has been in occupation with the benefit of security of tenure for less than 14 years, it's the rateable value. But if it's more than 14 years, then it's twice the rateable value. But yeah, it's the landlord that pays. The overall ethos of the Act is to sort of it intends to sort of protect tenants. It's to reflect that a tenant may have over time, spent money and time, and have some sort of locational goodwill that's built up from their use of the premises over the years. So that's sort of the general sort of the thrust of the Act.
Thanks, Miles. Next question. We are currently in lease negotiation with NHSPS as our landlord. Currently don't have a lease. Anything you would recommend to be wary of?
I think it's not specifically. I think it really depends on a case-by-case basis. I think I mentioned service charges before. I think you do need to be particularly aware of what the service charge terms are under the lease that you're being offered. Make sure you get budgets, you understand what sort of charges you can be required to pay. And then I think the other things I'd just say before entering into any or starting a formal lease negotiation process, make sure you check the heads of terms carefully. Get them, as Miles said earlier, get professional advice from a surveyor, solicitor, just to check over those nuts and bolts of the deal. Bearing in mind that once those heads of terms are kind of agreed, even though they're not binding, it does become harder to row back on particular points. Once the solicitors have produced the draft lease and you're into that stage of negotiations.
Yeah, thanks, Bryn. Next question. When a rent review is carried out with NHS district valuer, can their determination of rent be challenged if it is lower than the market rent as estimated by a certified surveyor? They've just followed up as well. As a landlord owning the property, what assurances of continuity of rent do we have if the medical practice tenant is a newly formed limited company, i.e. will the NHS step in if the tenant fails to pay the rent?
Right, there's two questions there, isn't it? Do you want to try one of them and I'll do the other?
I lost track of the first one. I can do the second one if you like.
Jess, can you repeat the first one again?
Yeah, so the first one is when a rent review is carried out with the NHS district valuer, can their determination of rent be challenged if it is lower than market rent as estimated by a certified surveyor?
Yes, I think that's the simple answer to that. There is I think it would be worth speaking to the value surveyor about that process. Hopefully they understand the system, but there's normally a local disputes resolution process to start off with, where the parties try and agree look at the ICB and district valuer should be asking to see evidence of comparables and looking considering whether there is there's any chance of resolving that dispute at that level, but if not, there is then a more formal process of applying to NHS resolution, which is, I mentioned earlier in that difficult lease renewal case, where if needs be an independent expert can be called in to consider the rent, consider the district valuer's position, and also any arguments put forward by the tenant or the practice, I should say.
The second part, I think, was to do with a landlord who's let the premises to a limited company, and I think the question was whether the ICB would step in the event, I suppose, that the limited company defaulted. I think the short answer is no. The ICB don't step in to sort of assume the liabilities of that entity. So a landlord would be sort of having to look at it like any other commercial deal, where you would have to be comfortable with the sort of covenant strength of that tenant financially, and if necessary, seeking other ways to provide reassurance, such as guaranteed, etc.
I think, yeah. I mean, I think one thing I would say there is that looking at this, there's no. You're right. There's no legal guarantee for the ICB would step in, but there is. If the ICB has approved a lease for a specific period of time, that does indicate that those premises are, well, hopefully likely to be required for to provide the health services to the local population for that period of time. Now, it's not guaranteed, but there's certainly an indication there. And of course, if the limited company, if it's entitled, if it's the contract holder, it's entitled to rent reimbursement. So there is that link with the state funded reimbursement that I mentioned earlier. So the question then is, if the limited company were to hand back the contract, what would the ICB do? Now, there's say, assuming the premises are required for the patients, and there was a retender of that contract, I think there's a good chance that the new provider would need to take over that lease. So it's not immediately guaranteed legally, but there is, I think sometimes you have to think about it in the kind of the wider, the wider picture. And also, it's worth mentioning in the latest premises cost directions, there are provisions in there now about NHS England publishing a protocol under which it will set out the factors it will take into consideration when recommending for a lease to be assigned to a successor in that sort of well, I guess where GPs have retired and there's no ongoing practice. So that it's worth watching that space in terms of that protocol when it comes out, and hopefully in the next few weeks.
That previous question, the person's just clarified that I need to clarify my question about the ICB stepping in. What I meant was what happens in real terms if the tenant's limited company fails. For example, premises, new provider, interim measures.
Well, yeah. Well, I hope the answer I just gave covers most of that. But if there's any specific points we haven't addressed, very happy to have a chat about it after.
I think the point might be that from the landlord's point of view, yes, there's no guarantee as such that the ICB or another contractor will step in, but as Bryn was saying, if the ICB have awarded a contract for provision of services from that premises, then you would hope and expect that would continue for at least the life of the lease. I suppose the other point is there's always that's a risk that all landlords will have with all commercial entities.
Yeah, I think it's worth just to make one other point. The lease itself does not end if the limited company ceases to be the contractor, or indeed goes and I mean there is it can be assigned potentially. So that's I mean, so I think it's quite there's quite a lot to it, but as I say, we're happy to take that offline and have a chat if that's of help.
We'll just go to the next question. Please, can I ask what assurances we should seek from our ICB when considering lease renewal? I ask this as there is often structural reorganisation and long-term NHS plans change regularly. Our landlord, BlackRock, wants us to sign a new lease for 25 years. We still have 7 years remaining on our current lease. Thank you.
Well, I think it's worth. As I mentioned, this protocol we're expecting to see. So I'd be interested. Yeah, it'd be interesting to see what that says in terms of what because there is. I mean, there's this concern obviously about last partner standing, which I think is a lot of GPs are concerned about now. There is obviously the best possible advice is try and obviously do all you can to make sure that you have a viable practice, and obviously succession planning is crucial to all of that. So ideally, you don't want to be finding yourself in a situation where you're having to hand the contract back before the lease, whatever length of lease you have, expires. So say with this protocol coming out may provide some comfort. It remains to be seen how much comfort. We do see from time to time letters of comfort that are provided by ICBs saying that if you were to hand the contract back, we would try and work with you to find another contractor who we would require as part of the tender process to take over the lease. But those are all. It's not all of that. I would say it is some level of comfort, but I think I always say, well, what is looking at the premises in your heart of hearts, do you think they will still be needed for the provision of primary care services for the whole duration of the lease that you're signing up to? Now, if they're modern, fit for purpose premises, and it's it's in a densely populated area with not much other alternatives, then I think you've got that at some level of assurance from the from just the facts of what the premises represent to the community. So there's lots of things to consider, and I think it'd be difficult to say on a case without going into specifics of a particular case what assurances you should be looking for. But I think that it would be, I would certainly say, look out for this protocol that's hopefully going to come out in the near future.
Thanks, Bryn. So next question. Somebody's logged on to the government website and they'd like to know how to identify which names are on the lease.
Well, yeah, yes, you'd have to access it. It's the land registry that you'd need to obtain the title from, or a copy of the lease from. Not so it's HM Land Registry website. You can download it from there if you have the title number, or if you don't, you can also sometimes find it with the address and postcode.
Yeah, they normally charge you, I think, £3 or something.
£3, yeah.
Or you can ask a solicitor to do it.
Okay, thank you. Next question. My surgery property has not had a rent review since 2019. The landlord wants backdated payment before we renew the lease. Please advise.
I think, well, we're happy to. I mean, I think it's one of those we would. I think I would certainly be speaking to a valuer about your options and the process for getting that getting those backdated reviews dealt with. I think that most reviews are dealt with by surveyors rather than solicitors. So, but in terms of the lease renewal, very happy to talk about that and how that links into the rent reviews. But I think possibly need a bit more information and maybe something we could take offline if that's of help.
Just to reiterate as well, in the slides you'll receive, you've got Bryn and Martha's contact details there. So please do feel free to contact them about that. Then our next question: if a leaseholder and landlord agree to current lease terms to extend, do I need a surveyor in this case or just a solicitor?
I would say it's always advisable to have both a surveyor look at those terms as well as a solicitor. I suppose the point is, I mean, I don't know the specifics of your case, but if for example it turns out that the solicitor says, well, this lease is missing certain GP specific provisions that we would want to see to protect a GP tenant, then it might be the case that those changes that you ask of the landlord then have some knock-on impact on the rent itself. In which case you're back into the negotiation around the figures, and then at that point you would want the surveyor on board anyway. So that's why I'd suggest it's just best practice to have both your surveyor and solicitor on board.
Yeah, I think. Yeah, and the other thing is has the ICB approved the rent as well in the terms? So I think I guess if everyone's approved it and there's no issues with the level of rent, no negotiations, then potentially you could go straight to the legal stage. But I think it really depends on the facts of where you are and whether everyone is on board with those terms. But I think the thing we say is that the solicitors, we can't advise on valuation points.
Mm-hmm. So
we can't say, for instance, what if you've got a break clause in the lease, what impact does that have on the rent and other things. That's not those we can advise a lot on. Sort of standard protections we'd expect to include in leases, but not those kind of detailed valuation points, which is why we recommend specialist valuers as well as getting legal advice.
Thanks both. So just our last two questions before we close off the session. So the first one: my lease with landlords are now Sorry, my lease with landlords who are all retired ex-partners has completed term in February 2023, but I think it is protected under the 1954 Act. They're asking if you could maybe review their lease and offer some support. So yep, there's you've got Bryn and Miles's contact details there. By all means, just email them, and you can explain what you need support with, and they can come back to you then. And then just a final question. Very few partners will have 20 years a new lease left in them. What risks do they hold signing a new lease?
Yeah, I think this all goes back to this last partner standing concern, and I think it is. I mean, I say a lot of people in a position where they're presented with a lease that may potentially outlive their life in the practice, as it were. So I think it's about succession planning at the end of the day. That is the key. The risks are that you have to hand the contract back because you don't have a viable practice, and then you have to find a home for the lease. Now, as I mentioned, this protocol that's coming out may provide some help with that, but I would not throw my eggs in that particular basket as an assurance. It's very much I think a kind of solution of last resort. So I think succession planning is the key, and I know that's hard in today's environment. I know it's tricky getting new partners in, but that's the key is to keep that turnover of new partners coming through, and or finding other options, mergers, or ways of just keeping the practice viable, so that you don't the partners that come up to retirement can retire and hand over those lease responsibilities. Thank you.
Brilliant. Many thanks.